chamber events. No boring speeches this month for you guys to hear me. This is a professional development program. I want to introduce Helen Rose over there. That's our chairperson for professional development. These are every quarter, varying topics, usually of interest to our members. And I appreciate you coming. So they're going to be, put it on your calendar, it's the second Tuesday of the quarter. So the second Tuesday of the quarter. So that would be, I'm not doing the math, sometime in October. We'll have another one. Our business meetings, if you want to attend, where we have the board meeting, it's a very quick 1-hour meeting. It's at M&T Bank. In months that we're not having our breakfast meeting, that is on the second Friday of the month at M&T Bank in their boardroom. And we do our business. And we are a pretty big group now. We have been growing steadily. This association, this chamber's been around since 1983, but we are going full steam ahead here with there's a lot of people in the room that are contributing to all the activities that we're doing. But to give you a heads up, we do a lot of networking events, so follow our page, Facebook. If you're not getting invitations, just let us know on your email. We are having our scholarship fundraiser for the Mount Airy Bull and Oyster Roast to support our scholarship program. The date on that is already gone off here. Let's see if I can remember the code here. Yep. That's going to be October 27th to Sunday. We'll have the football games on from 1 to 5 at the American Legion Hall. Hopefully you know where that is. Pit beef, pit ham, pit turkey, and oysters, shucked oysters. So that's going to be to raise money for our scholarship program. So that'll be the Mount Airy Annual Bull Roast, Bull and Oyster Roast.
Number one.
We're hoping this is going to be a phenomenal event every year. And so we're going to kick it off in 2024, October 27th. Okay, so today we're going to do our traditional around the horn real quick. So I'm Jim McNeil, I'm the president of the chamber. I own a company called Guidemark Strategic. It's an investment planning company with Cambridge Investment Research. We have an office, do a lot of work in Mount Airy, obviously, and also in Frederick and in Rockville. We have offices. And starting over here, Pat, maybe you can start us off. Really, if you haven't done around the horn, it's really quick. Hey, this is what I am, this is what I do, who I am, this is what I do. Go ahead, Pat.
Patrick Reed with Reed & Son Services, plumbing service company based out of Mount Airy here.
Dwayne Bersini Electric Service, your friendly neighborhood 5-star electrician that has a wire. We're the company to hire.
Ken Sikowski Construction Services, general remodeling and shading, awnings.
Brian Pruce with Green Home Solutions, locally owned, veteran-operated indoor air quality company, testing and remediating for mold, indoor allergens, VOCs, and particulates.
I'm Margaret McNeil. I work for Wallace Consulting and Construction. We are a general contractor out of Highland, Maryland.
I'm Alan Hirsch. I believe in making a difference in people's lives. I work with business owners and CEOs as an executive coach, helping them find better ways to grow their business and grow their brands.
Helen Rose, Launch Consulting. Also the chair of the Business Development Committee here and assistant professor of entrepreneurship at Howard Community College. My business, Launch Consulting, does marketing strategy and website development.
I'm Pat Scholl, and I'm with Cruise Planners 2x2 Travel, and provide travel assistance anywhere in the world. And if your plans unravel, call 2x2 Travel.
Pete Marius, I'm an attorney and real estate agent in commercial and residential, agentpete.com.
Karen McCord, Reporter County and Tax Service. I do individual and business taxes, and I also help people with their books.
Karen McGibbon, Senior Helpers, we do in-home senior care.
Good morning, I'm Amy Thomas with Horizon Business Services, HR Consulting. I'm Courtney Pagan with Pagan Clean, your local friendly exterior cleaning company. We serve both residential
Smith, Task for Corporate Services, full service accounting, tax strategy and advisory, with clients all over the country, and I'm also the treasurer for the chamber.
Dorota Bennett, Senior Relationship Banker for M&T Bank, and I'm helping here for the chamber's legal membership.
And I'm Linda Coons, retired, and still working on membership.
I always tell Linda she's our COO, Chief Operating. So, July 9th, not really always a great time to get together and have a seminar, but today I think John Wheatman is worth it. John is a well-respected guy. There's a reason why we refer to him as the entrepreneur's lawyer. And of course, John, I'm gonna go over just a couple of highlights of John, but he's a Maryland guy. He's got his law degree from Maryland and his undergrad Maryland. I guess his MBA is Loyola. So we like that. We like these Maryland guys come in and tell us what we need to do with our companies. John's also a member of the chamber, so he will be in the directory if you need to talk to him. I'm gonna let him kind of tell you how he specializes in law for entrepreneurs, and but we really are very happy that he agreed to do this because it's just an indispensable topic. This was one of the big things that we wanted to put on our professional development. And out there, there's a lot of reasons to have a lawyer on your side, really, for this type of business law. So anyway, with that, I'm going to give the floor to John Wheatman. How about it, John?
All right, Jim, thank you very much. I want to thank the Chamber, certainly, for this opportunity today. It's always good to get out and talk to business owners and managers and about some of the things that are going on. Sometimes our state and federal governments have a way of saying you need to do these things, but they don't tell anybody they need to do these things. And that's some of what we're going to go over. But before we get into that, as Jim mentioned, I would like to take just a couple of moments to tell you why maybe I'm a little different than some of the attorneys out there. Reason number one is I didn't go to law school until I was 40 years old. I had a corporate career before that, had my MBA, undergraduate degree in business, and at some point I decided, gee, what a great idea it would be to go to law school, better critical thinker, better writer, help my corporate career. And then once I did that, I thought, I'll take the bar exam just in case, and then for some reason I passed it, and then for some reason I became an attorney, so here I am. But the only reason I really bring that up is I had almost 20 years of business experience sitting where you're sitting, running some very large divisions of corporations and having a business or two of my own. So when I approach law, I do approach it through the lens of the business owner. So I really prefer to practice, to the extent that I can, proactive law. And that's what I'm here to do today, is to tell you about some things that you may want to know about, some things that are new, so that you do these things ahead of time and you can just focus on your business, and so it's not so much of the legal problems. So let me get be a show of hands so I can dial this in a little bit. How many of you here own your own businesses? All right, just about everybody. Others are franchise or management? Okay, all right. How many of you are working as LLCs? Okay, any corporations? Okay, S-corps? Okay, a few of those. All right, excellent. That helps me kind of dial things in a little bit. So when I was asked to pick a topic to talk about today, I thought, I'm not going to pick a topic. Let's pick 5 topics. So we're going to go through some of these at kind of a 30,000-foot level, but I do want to make sure that you have an opportunity to ask questions and have my contact information afterwards. If you're hearing something in any of these topics and you decide, I really need to know a lot more about that, I want to make sure you have the opportunity to do that. So, and of course, there's a lot more than 5 things we need to know as business owners. So this is, I promise you, the only slide I'm going to read you verbatim. I won't do it again after this, but this is today's fine print. It's important, it's critical that everybody knows that the information you receive today is general legal information. It is not specific legal advice. In order to provide specific legal advice, I would need to review your individual circumstances in detail, and we would formalize that relationship via a representation agreement. Our conversation today does not constitute or form an attorney-client relationship. Should you require specific legal advice, I suggest you retain me or another attorney of your choice. Pete, is that okay? That sounds good to me? Okay. All right. So what I'm really telling you here is if you hear something today that you want more information on, or you're looking for legal representation, contact somebody. Please don't take the things I'm telling you today and say, well, John Wheatman said I should do this. I don't want you to do that only because we haven't had a conversation and I may not fully understand your circumstances so that I can say, this is the thing you should do. Okay, so let's get that out of the way. All right, so let's dive into it. The actual 5 things we're going to talk about today: the BOR, U.S. Department of Treasury, recent changes to the business personal property tax. We're going to talk a little bit about S Corp, Maryland Healthy Working Families Act, estate planning, and really how it relates to business ownership. And then I had a couple people suggest to me, well, what about this? If we have time, there'll be a bonus topic there too that we'll get into. So we'll dive right in. Okay. Well, forgot my quote. Yo, Adrian, knowledge is power. Rocky Balboa. I don't think he ever said that. All right, so let's talk about the BOIR, the BOIR. It's new in terms of policy this year as of January 1, but the Corporate Transparency Act was passed a couple of years ago. It just took the Department of Treasury that long to decide what they were going to do under the Corporate Transparency Act. So what it does is it requires every corporation and LLC that has 25 or fewer owners, shareholders or members, to report to the U.S. Department of Treasury who owns the LLC. Like, you may not know this, but when you file for an LLC in the state of Maryland, there's nowhere in there where you have to list who owns the LLC. So it's always been kind of cloudy, and frankly, it has been an opportunity for people to use LLCs for money laundering. So there's a purpose behind this. So who has to do it? If you're a nonprofit, you're exempt. You have 25 or 26 employees or more, you're exempt. There's a few other odd exemptions to it, but for most of us, we have to comply with this. Anybody who owns 10% or more of the LLC has to be reported. Okay? So it's serious business too. If you formed your LLC, your business before January 1 of this year, you have until the end of this year to do it. If you don't do it, they have the right, the feds have the right to fine you $500 a day and actually up to 2 years in jail. I'm not saying they're gonna do that right out of the chute, but they do have the authority under the law to do that. So this is pretty serious business. If you form an LLC this year, and from now on, you have 30 days from the formation of that LLC to meet this requirement, or you're subject to the same $500 a day fines or up to 2 years in jail. So how do you do it? There is a fincen.gov. That's actually the Financial Crimes something division of the U.S. Department of Treasury, and you go on there, and basically what they want is a driver's license front and back, social security number, home address of the folks that I talked about before, the LLC owners, the members, anybody who has more than 10% of the business. It's not terribly hard to do. You do have to be careful at the end to make sure that you get that receipt that you filed and save that somewhere important, because Department of Treasury has gone from not having this program to having this program and having hundreds of thousands of required reporters. And frankly, I don't trust them to pull this off correctly. So I have a lot of concern for my clients that we're gonna get a lot of false you didn't file. So you wanna make sure you do it right. It is something I do for my clients. If you're interested in more information on what that would look like to have me do it for you, I'm happy to have that conversation. But please, please just make sure it gets done. Okay, so be very, very quiet. We're hunting money launderers, and that came directly from Deputy Secretary Fudd. So any questions on this? I'm sure we're gonna go through these things at a high level, but probably most of the people in this room are required to do this. If you're an LLC owner, if you have questions on how to get it done, let me know.
Never heard of that.
Yeah, and you won't, yes.
How long does it take? How hard is it? Is it just a driver's license? Is it more than that?
It's the first time I did it, I did my own first. It took me about 45 minutes. Now that I've done them for a lot of clients, it takes me about half an hour. The website is not the best you've ever seen. Yeah, so there's some wading through it. Absolutely. It's a good question. All right, so let's talk about Maryland's business personal property tax. This is also, if you've been in business a while, you probably know what this is. But the state is not really, really good at letting new LLC owners know that this thing even exists. It used to be they mailed everybody out a return to fill out and send in, and they said, no, we're gonna go all electronic. We're gonna email everything. But they don't have a good list of emails, so some of you may not get this. If you do not pay your Maryland business personal property tax, your LLC will show up as in not in good standing for a while. And they're not gonna tell you, it just happens. If you're not going on the state website to check, you won't even know. And then eventually that not in good standing turns into this business is forfeit. and you don't wanna live there, because that means the state of Maryland no longer recognizes that you even have an LLC. You're not really allowed to operate as an LLC, and it's gonna cause you a whole world of problems. So, LLC owners here, most of you know about this. I'm gonna talk mostly about the changes to it, not so much the fact that it exists. But I do get people more often than I would like to call me and say, hey, I went to get a loan at the bank, or I went to do this, and my business isn't in good standing, tell me what happened. Well, you never paid your business personal property tax because maybe you didn't even know that you had to. So let's talk about the changes a little bit. The exemption is now $20,000. It used to only be $2,500. If your business has less than $20,000 in assets, and that's at a depreciated rate, you are not subject to the tax. But hold on, that doesn't mean you don't need to worry about this. Stay with me. You still need to worry about this. You just don't owe the tax. So that covers most of us that have home-based business or administrative type companies. For example, my assets in my law practice, because I'm a solo, are well below $20,000. So I don't have to pay the tax. But you still have to do the annual filing, or you'll still fall into that. You're not in good standing, and then eventually your LLC is forfeited. And as you saw before, it is due annually by April 15. So as I just said, you still have to file. It's $300 to file, unless you participate in a program called Maryland Saves. This is relatively new. This is one of the changes. The two positive changes they've made is taking that $2,500 exemption and bumping it up to $20,000 exemption. The second positive change is that if you don't want to pay the $300 filing fee, you can participate in Maryland Saves. What Maryland Saves is an opportunity for your employees to save for their retirement. It doesn't cost you anything as the business owner. You just go in and register and tell your employees that they're now eligible for this program. Once you do that, there's a couple buttons you click to say, yes, I'm certified Maryland Saves. And then when April 15 comes around next year, you just check that box that you're registered with Maryland Saves, and you don't have to pay the $300 filing. Make sense? So those are the changes. Okay. So I think their slogan should be the Maryland Business Personal Property Tax. At least it's not as bad as it used to be. And part of the reason I say that is a $300 filing fee every year for your LLC is the highest in the country. And I've been railing against that down in Annapolis for years. I don't know if I'm gonna get anything done. I'm not the only one. Most states it's $50 or $99 to register your LLC every year, but Maryland they hit us for $300.
Can I ask a question? You said that if you go in and you're not in good standing, this is why. Is there any other reason you would not be in good standing?
Yeah, claims by Department of Labor for unpaid wages. There's a whole bunch of reasons you could be not in good standing. But I'm willing to bet that 80% of the businesses that aren't in good standing is because of this. But yeah, there certainly are other reasons. And I should mention too, if you're not in good standing and it is because of business personal property tax delinquency, as soon as you go in and file that, you're back in good standing. Now, if you reach forfeiture, there's still a path back. But depending how long you've been in there, it gets a little more complicated. You can file articles of revival with the state, and that gets a little bit complicated to do it exactly the right way. But you can breathe life back in that LLC. If you see forfeit, don't panic. It can be done, but it's kind of an exacting process to get it done correctly. Right. Questions on that one? All right, demystifying the S Corp. And I've got a CPA here in the room, so she can straighten me out if I don't get this right. The reason I say demystifying is I get a lot of people that come to me and say, oh, I don't have an LLC, I have an S Corp. And it's semantics, but often what you're really telling me is I have an LLC, but I've applied with to the IRS to be taxed as an S Corp. So the S Corp from a legal standpoint isn't really a different kind of business entity, it's a tax status. So why would you even want to do an S Corp? What's this thing all about? So, that was small. So what it isn't, as I said, it's not an actual type of business entity. Man, I must have been tired when I did this because that is the worst joke ever. What it isn't, a scorp is not something with ions that rocks you like a hurricane. That's really obscure. If you're into German metal bands, you'll get it. I'm not, but I got it. Okay. So as I said, what it is, it's a business structure designated by the IRS. It happens to fall under their authority under something called Subchapter S. It's a Subchapter S corporation is what it is, S Corp for sure. Okay. So why do you care? Because eventually, at a certain level of profit, you get taxed less as an S Corp than you do as an LLC. I don't know if you guys know this, but the IRS, their exact words for an LLC, you know what they call us? Disregarded entity. So the way I look at it is the IRS looks at us LLC owners and says, that's cute, you got an LLC. That's a state thing, we don't care. We get taxed at our personal income tax rate as if we didn't even have a business. That's how we're taxed as LLC members and owners, unless you're an S Corp. There's a self-employment tax we pay. It's pretty hefty. And it kind of takes the place of what you would normally pay in your payroll taxes, but we pay it as a self-employment taxes on our personal tax returns, our Schedule C, right? Karen, keep an eye on it, right? Right? Okay. So there's a certain point at which the profit you're deriving and that self-employment tax becomes so onerous that it then becomes better to pay yourself as an employee and pay the payroll deductions, and that way you're not paying that self-employment tax. A little bit of a simplification here, and you wind up having less tax burden, and the only way to do that as an LLC owner or member is to go the S Corp route. So now you're telling the IRS, hey, I want to pay myself as if I'm an employee of my own company. I'm going to pay all the regular payroll deductions that any other employee would pay, but now I get to largely skip the self-employment tax. The exception is that you cannot pay yourself more salary than what that position generally would pay. So let's say, this isn't true, it's hypothetical, it's a good one. Let's say I make $1 million as the entrepreneur's lawyer, profit. I can't pay myself $1 million salary, that's outrageous. So I can pay myself what's considered a reasonable salary, avoid the self-employment taxes on that salary, but then I'm still gonna pay the self-employment taxes on what I bring in above my salary level. Okay, again, it's a little bit of a simplification, but that's how that works. So why else do you care? Because you typically want to escape the jaws of C Corp double taxation. If you were to say, well, hey, can I just form a corporation and then I don't have to pay the self-employment tax, I can pay myself as an employee? Well, yeah, you sure can. But what happens is, under general C Corp status, you're paying taxes as the corporation. The corporation pays its taxes, then you pay yourself and you're paying the taxes again. With an S Corp, you don't do that. You don't get the double taxation, you only get taxed as the employee. So that's why this is attractive, and I saw some hands here. You guys are already S Corp, so you probably know all this. But that's what we got going on there. So how do you join the S Corp club? Again, this isn't quite that simple. This is another gross simplification, but there's a form. There's actually a couple forms depending on your status, 2553 to the IRS, where you're saying, hey, pretty please, will you tax me as an S Corp? There's some other considerations there too. Often it makes sense to perhaps unwind your existing LLC, start a new LLC. There's some things that you need to do that make your LLC look a little bit more like a corporation in terms of some internal documentation and things that we do during that transition from LLC to S Corp. So it's a little more than just filing the form. Let me put it that way for now. And the same thing holds. If you want advice on this, get with a tax professional, get with an attorney, and one of us can walk you through this kind of thing if you're interested in S Corp. But we really want to make sure you're not paying too much for your self-employment taxes. And Karen, this is, you might want to hold your ears for this because this isn't precise. But you know, if your profit is $20,000, $30,000, $40,000, you don't really need to worry about an S Corp at this point. You're not paying more on that self-employment tax. If you start to hit 70, 80, 90 in profit, then you want to start looking at this and have that discussion. But there are ranges and other factors there. But just to give you an idea of where you may be situated, if you're profiting a couple $100,000 a year, you definitely want to be talking to somebody about an S Corp. All right, so as I said, consult with a professional before choosing to become an S Corp. It's easier to do than it is to undo, so you want to make sure it's the right thing for you to do. I have occasionally had a client who said, yeah, I formed an S Corp with my startup. I'm like, why did you do that? You're not making that kind of money yet. But, yeah. All right, Maryland Healthy Working Families Act. Those of you in here that are working on your handbooks, you've certainly heard of this, but how many in here have heard of this? Okay. Yeah, it's another, unfortunately, well-kept secret. This is a law that's been in place for several years now in the state of Maryland. Part of my frustration with it is that for the first time that I'm aware, Annapolis decided that we're gonna pass this huge piece of legislation, this huge benefit to employees that changes everything. And used to be, it'd be like, well, if you have 100 more employees, this applies to you. If you have 50 more employees, this applies to you. If you have 25 or more employees, this applies to you. This applies to you if you have one employee, one and up. So let's talk about what this is. I still run into an awful lot of clients that don't have any idea it's out there. It's not your fault. It's that we pass these things and then we don't tell anybody about it. Okay, so as I said, with even one employee, it's been in place since 2018. All right, so this could be a difficult topic to talk about because it's really very complicated. So I'm just gonna try to give you the upper level things to be thinking about, and then again, consult with somebody if you have concerns about it. So it mandates unpaid leave if you have 14 or fewer employees. If you've got 15 or more, that leave becomes paid leave for certain employees. So who are the certain employees? Those employees that regularly work more than 12 hours a week. And if you wanna know what regularly means, they've come out with the definition of regularly, because everybody's saying, what does regularly mean? And the definition they came up with, regularly means what regularly means. That's very close to what they stated, so I don't have a lot of help for you there. They have to have turned 18 before the beginning of the year. We talk about FTEs. That's the equivalency of full-time employees. So if you're trying to figure out, like, well, I got 10 part-time people and I got 6 full-time people, if your part-time people roughly work half of full-time, 20 hours a week, then your 10 part-time people count as 5 full-time, your 6 full-time count as 6 full-time, you got 11 full-time, so you would fall at the 14 or less. Okay? Again, there's more to it than that a little bit, but just to give you an idea, if you're trying to calculate your 14 or my 15, if you've got somebody who's working a third of time, they're a third of an FTE, the equivalency of a full-time employee, so that's how you add those things up. There's an Ocean City carve-out, which I think is interesting, that no one is eligible for these benefits for the first 106 days of their employment. You know how long the summer season is in Ocean City for the temporary workers they hire? 105 days. Okay. So they did that for Ocean City so they don't have to give them time off during the summer. And there's a lot in this law with stuff like that. So what does it really mean? Every worker you have accrues 1 hour of sick and safe leave for every 30 hours they work. So that's a lot of fun tracking that, right? How many of you use payroll services? A few of you. Your payroll services company should be tracking this for you, but make sure that they are. I see them make mistakes. I see some that say, well, that's an add-on, you have to pay extra for that. We're not doing that. So make sure that your payroll services company is doing that for you if you want them to do that for you. So now they're accruing 1 hour for every 30 hours work. So I'll come to number 4 in a minute. So they are allowed to earn up to 40 hours a year. And then that's it. So 1 hour for 30 hours work, 40 hours, 14 fewer employees, it's unpaid leave, but you have to give it to them. 15 or more, it's paid leave. Okay? So there are enumerated uses that you may not deny. There's a whole list of them within the Act. They're sick, kids sick, spouse is sick, partner sick, paternity leave, they're being stalked, they have to appear in court related to a domestic violence or some other related type case like that. There's a whole bunch of things listed there, and again, you may not deny them. I have clients that are in such businesses such as landscaping or other things where they used to have a policy, no leave in our busy season. Don't do that anymore. They're entitled to this leave, and you cannot tell somebody they may not take it. There's also a lot of rules in there about notice. Okay? If they cannot have reasonably known they needed to leave, they don't have to give you any notice. They can tell you, I'm not coming in today. If they have a doctor's appointment or something, it was reasonably foreseeable, then you can require up to 7 days notice. Again, for those of you who have worked on your handbooks, this becomes one of the largest sections in your handbook. That's how complicated this thing is. So there's strict limitations on notice. You have to be really careful what you're requiring of them to make sure it comports with this law. A growing area of complaints with the Department of Labor in the state of Maryland is, hey, my employer didn't treat me properly in terms of sick and safe leave. I didn't get the right hours. They told me I couldn't take leave. They added 5 more employees. I'm supposed to get paid leave now. A lot of these things are popping up and a lot of complaints against businesses. So again, in the spirit of being proactive, know that this exists. Okay, I just talked about the written requirements for your employee handbook. So I'm going to talk about the front load or front load because that is the question. You have a choice as the employer at the beginning of the year to say, hey, you know what? I'm going to give you your 40 hours right up front. Take them as you need them. You still have to give me notice where you have to give me notice, but take your 40 hours. That's option 1. Option 2 is, nope, you're gonna use it as you accrue it, or you're gonna earn it as you accrue it, and you can take it as you earn it. It's an important consideration because at the end of the year, if you've gone with option 2, meaning 1 hour for 30 hours worked, first 30 hours, I got 1 hour of leave, second 30 hours, I got 2 hours of leave. You go all the way through, if you do it that way, they are allowed to roll over up to 40 hours into the next year. Because they didn't have access to them all year, they earned them as they go, so they can roll them over. The maximum amount of hours they can hold at any one time is 64. So they can't roll over for 10 years and then tell you they got 1,000 hours, right? If you give them the first option, here's your 40 hours at the beginning of the year, use them at will, then they do not have the right to roll any over. If they don't use them, they lose them. So that becomes an important consideration for your business. And some of the practical aspects are, if I give my employees 40 hours in January, are they gonna use those 40 hours by mid-February? Some people do. They just use them up because they have them. But that's mostly a business consideration. Legally, you can do it either way. It doesn't really matter a whole lot, other than how it affects your business, doing it one way or the other.
What's your recommendation?
It really depends on your workforce. Now, for most small businesses, again, this is practical, not legal. If you give them the 40 hours up front, and guess who's not counting 1 hour per 30 and trying to figure out how many hours do you have, how many hours do you have? You took 4, you only had 3. So from an administration standpoint, upfront, certainly a lot simpler. Yeah.
If they leave your employment during the middle of the year, they've used their 40 hours up, then you've lost that, right?
Correct.
Yeah.
Correct. Yeah, and that's a downside to it. As I said, somebody will use their 40 hours before the middle of February and quit on March 1st. You know, so you're rolling a die on that.
But they can use it before the 101 days or?
No, you're right. 105 days, they can't use it for 105 days.
So,
So push that back into
It's got
April.
90 days in it.
Yep.
So 100 days.
Yep, absolutely. He's going somewhere with that.
Do you have to pay out if they leave?
That's where I was going with that. That's an excellent question. The question was, do you have to pay out if they leave? The law in the state of Maryland is if someone has accrued leave but not used it, and you haven't told them to the contrary, you have to pay them upon separation, upon termination. So if they got a week's vacation, if they got 40 hours of this, you gotta pay them. Unless it's your written policy and they have received notice that they do not get paid for accrued but unused leave upon separation. If something, unless somebody tells me not to put it in there, that goes in every employee handbook that I draft, okay? When you leave, you're not getting paid for any accrued but unused time. And that's perfectly legal if you've given them notice. No notice, they get it.
Just on a side note to that, if you have a commission salesperson and they leave, are they entitled to their commissions as long as those sales are out there, or?
You cannot deny anybody anything they have earned.
Okay.
So if they sold a job and they leave, you gotta pay them. Subject to the normal things we get when they're working, like I know a lot of commission people that if you don't get paid, they don't get paid. If there's an adjustment of the amount of profit that was made on the job, their commission comes down. If that's all part of your written policies, then when they leave, you do have the right to say, I'm gonna pay you for this, but not until these things happen, same as if you were working here. So you can delay it based on that, but if anybody has earned anything in terms of actual work, you gotta pay them. There's no ifs, ands, or buts to that. Commission. Yeah.
Is there something that says they can take a certain number of days off without notifying you that they're not coming in?
They have to notify you. Most employee handbooks I draft is that if you don't come in and we don't hear from you for 48 hours, that's job abandonment, you're automatically
Even
terminated.
under the Maryland Safe and Sane?
They
like,
still have to notify.
They still have
Yeah.
to notify you like day one?
Yeah, if they're due to come in and work at 9 AM, and they tell you at 8:55 they're not coming in, and it's one of the enumerated reasons, and they had no reasonable chance of knowing in advance they needed the time off, they can take it. And I'm gonna tell you right now, you don't wanna start the fight. If they call you at 10 and say, I'm not coming in today, then you don't wanna fight that, okay? But if they don't call you at all for an extended period of time, usually 48 hours, that's considered job abandonment. They can't just no-show. All right, so on the other hand, Karen?
So, I had worked somewhere where they had the sick and the PTO as one, so that it was only labeled as PTO, so you would have to use PTO if you were sick.
Yep. Yeah, also a good point. Nothing in here says you have to put this on top of what you're already offering. In fact, again, in terms of simplicity administration, I recommend to many of my clients, let's just call it PTO. It's not sick leave, it's not vacation, it's not anything, it's just PTO. Or if it's not paid, it's just time off. So you can take this and combine it with what you already have and max it out at the 40 hours. You don't have to add this to what you're already doing, you don't have to enhance this, you just can't be below this. So this sets the mark. Okay. Anybody's business based in Montgomery County? Okay, I won't go there. They had a law like this before Maryland did, and it was grandfathered in. You even get more in Montgomery County. We won't worry about that today.
For businesses in Montgomery County or businesses that do business in Montgomery County?
Businesses located in Montgomery County. All right, so what I did is I summarized a lot of the other information for you here, because we don't really have time to get in it today, so, all right, you guys have that?
Yeah.
Good, all right. Mhm. There's some more. Got it?
Line 10.
I can't see it from here, you can see it. All right, and that kind of finalizes it, some of it there. That's just the first section of the act. I'll summarize that for you. All right, so estate planning and business ownership, unless there's any more questions on that, again, I wanted to cover a lot today, but I don't want to rush through it to the point you're sitting there with questions, so let me know. And depending on how we're doing on time, we'll have time for questions at the end, and I hope. So estate planning and its terms of overlap with business ownership. If you are an owner of a business, your estate planning is sort of a different animal from the average person. And what I don't have time to do here today is to go through an estate planning presentation, because that would take all the time we have and probably then some. But let me go through just a couple of basics that'll frame our conversation. So what is an estate? An estate is anything you own solely in your name at the moment you pass. That's your estate. Keywords being solely in your name. If you and your spouse are on a home together, if that's done properly, that's not in your estate. If you have bank accounts with right of survivorship, somebody else is on the account, that's not in your estate. It's things that you own solely, and very often in estate planning, we try to get that estate as small as we can by making sure that assets that can be duly titled go to this person or that person at the moment you're hit by that bus, so that it doesn't even go on the estate. And part of the reason we want to do that is we want to avoid probate. So what is this probate thing? If I get hit by a bus tomorrow and I'm no longer with us, there's suddenly an estate. The personal representative named in my will has to go to the Register of Wills and say, here's a death certificate, here's a will, I'm supposed to be personal representative, I need to open the estate. That's the beginning of probate. And there's a lot of requirements there, I'm not gonna go into them all today, but you have to give notice in the newspaper, this person's passed, did he owe anybody money, so we can pay it out of the estate. Then you gotta wait for those claims to come in, and there's a large estate, and there's a small estate. The small estate process is easier, but this is all probate. And once that claims period is gone, and nobody else is claiming anything, then the personal representative takes your stuff and doles it out according to, with the permission of the Register of Wills, doles it out according to what your wishes were, and then eventually the estate is closed when the personal representative says, that's all there is, there ain't no more, it's all gone, it's all been doled out accordingly. And then it's closed, and that becomes the end of probate. There are fees associated with that. You have to pay a fee to the state of Maryland for probate. The personal representative is entitled to take a fee. So that's part of the reason we want to keep the estate as small as possible. If you're getting into estate values of $6, $10, $12, $15 million, good problem to have. But this becomes very complicated, and I'm not talking about that today because there's a lot of tax issues that become involved there. But for most of us, the exemption on that is millions of dollars, and it's not going to affect us. Okay? So that's all I'm going to talk about in terms of estate and probate. So what about business ownership? What are the special considerations? So first thing you need to think about are, what are your goals with your business? If we get hit by a bus tomorrow, do you want the business to continue? Is that the only revenue source for your family? Is your family dependent upon that business? Do you just want to have it cashed out and the cash go to your heirs? Maybe you have partners. You have other members in your LLC. What happens to your share in the event you're hit by a bus? So that's the very beginning of estate planning for business owners, at least for me, the way I do it, is understanding what are your goals? Because they can be very, very different, and your estate planning will look very, very different as well. So is it an orderly transition? Do you want, let's pick a partnership. We got an LLC with a couple of members. Okay? And I'll circle back to that if one of the members is a spouse or partner. So I've got a partner in my law practice. I don't really, but another attorney. And we set it up such that if I get hit by the bus, then what I want is my membership interest to transfer to my partner, but we can also set it up where the partner has to buy that membership interest, and then my heirs benefit from what my stake was in the LLC. That can be done. I can also set it up where, because your LLC membership is considered in essence real property, not like land property, but it's considered property. So I could also set it up such that, let's say my daughter was an attorney, she's not. I could set it up where I get hit by a bus and she gets my membership interest. Well, because it's a law firm, she'd have to be an attorney. But for you, you could have any of your spouse, anybody, then gets your share. So now we have original LLC member and new LLC member. Okay? So you can do it that way too. If you've got somebody in the family that's involved in the business, wants to run the business, you can do that. You can do almost anything you want to do. The important thing is to make sure it's done. So how do we do that? Okay, talked a little bit about tax consideration. So for LLCs, we have operating agreements. Those are the rules of the game for that LLC. You can do a lot in an operating agreement. There are very few things in there that the state of Maryland is going to say, no, 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 you can't do that. But that's the rules of your game. And a good operating agreement includes, and I'm talking about multi-member LLCs now, how do we get into this? How does it operate when it's operating? And then sometimes the part that gets skipped is, how do we get out of it? And it could be for a good reason. Maybe partner hits the lottery and is buying an island and off they go. Okay, well, how do we wind them out of this? Sometimes it's for a bad reason. Partner gets hit by a bus. What happens then? Okay. I've seen cases too where what happens if partner starts to suffer from dementia? It's not fun to think about, but these things happen. And the operating agreement has to account for all of those things. Because those are your rules. This thing's got a range of about 8 feet. Here we go. All right, let's talk about dueling documents for a minute. The courts have begun to clear this up, but it was a big deal about 5 years ago where we had a multi-member LLC, partner A, partner B, partner A dies. Well, the operating agreement said, my membership interest goes to my partner. And member A's will said, all my worldly possessions, everything I own, goes to my spouse. Guess what spouse did? That membership interest, that's his property. The will says it comes to me. Right? Let's take a guess here. All right, show of hands if you think the operating agreement prevailed and the partner got the LLC. Okay, a few of you. All right, how many of you think the will prevailed and the spouse got the LLC? Okay, you're correct. And the reason they did that is they said, okay, giving something to somebody that was mine, that's in my estate after my death, sounds like a bequeathment. This is what the court said. And if it's a bequeathment, that sounds like a will. And why does that sound like a will? Because a will is signed and witnessed by 2 people. Is the operating agreement witnessed by 2 people? Okay, so we had a real problem there, and there was a lot of panic in the world because everybody, they should have been checking their operating agreements and their wills to see if we have dueling documents here. The courts have straightened this out a little bit, but I began drafting operating agreements with 2 witnesses at that point. So you wanna make sure that whatever testamentary documents you have match. Wills, operating agreements. Again, there's no right or wrong in how you want it done, but you wanna make sure that they are the same. All right, so let's talk briefly about financial versus management interest. The laws are set up, and hopefully your operating agreements, if you're multi-member, are set up such that you're not gonna be forced to be in business with somebody you don't wanna be in business with. So hypothetically, but this happens all the time, partners A and B getting along great. Partner B gets hit by a bus. His membership interest goes to spouse or kid or brother or somebody. And then partner A has this new partner that they hate, who doesn't know anything about the business and wants to run the show and is just trying to milk the business out of all the money, and I just doubled my pay and da-da-da-da-da-da. That's not a good place to be. So a good operating agreement says partner B gets hit by a bus, his membership interest goes to the heir, perfectly fine, perfectly legal. But what we're gonna do is we're gonna limit it to a financial membership interest, which means this new partner is due the money that the old partner would have gotten. You still gotta write the checks, but they have no management interest. So they can't tell you what to do, they can't change the color of your trucks, they can't move your business, they can't double their salary, they can't do anything, they just have a financial interest. So it's also very important if you have a multi-member LLC, that you're talking about that financial versus management interest. So a lot of what I just talked about related to multi-member LLCs, but think about this if you're a sole member LLC. If you're the only one on there, got a bank account, you're the only signatory in the bank account, you got money coming in, you got contracts, you get hit by a bus, your LLC is gonna go into probate. Which means until the personal representative is appointed, nobody can write checks, nobody can pay bills, nobody can take money into the household fund. That LLC in essence can become frozen in probate. And if somebody fights it, it can be frozen in probate for a long time. So you do want a succession plan for your LLC based on what your goals are. Is it continuation of the business? Is it cash out to heirs? Is it transfer the interest to somebody else in exchange for cash to the heirs? Any of these things are copacetic, they're all legal, but what do you want it to be? This is why estate planning for business owners is a little more complicated for everybody else. All right. Questions on that? Because again, you don't want to find yourself in business with this guy. Your partner's brother comes in, is going to run the show. All right, so how are we doing on time?
We're good, I think.
9:45?
Yep.
Okay, 15 minutes? Oh, perfect, okay. All right, so this is the bonus content I told you about, and then we'll open it up for any general questions that you have on what I talked about, or maybe even not what I talked about. But a couple people come up to me and say, you know, this employee separation thing, when I have to fire somebody, you know, it's scary. Because you hear all the time about all the unemployment claims and all the wrongful termination claims, and it can be a real nightmare, it really can. So I want to talk about that for a few moments. So, separation, termination, firing, it's all the same thing. We tend to use the kinder words like, oh, I separated an employee. All the same thing. So the first step is, are we going to do termination for cause or for no cause? And the reason we ask ourselves that is that Maryland, like 49 of the 50 states, are what are called at-will employment states, which means you can hire somebody anytime you want. You can also fire them anytime you want, as long as it's not because they're a member of a protected class. And I'm not even going to get into that too much, but you can't fire them because of their ethnicity or color or marital status or any of those kind of things. But you don't have to keep somebody on. Now that's true as long as there's no employment contract. Okay. Any of you using employment contracts with your employees? Okay. Unless you're trying to attract high-end talent that expects an employment contract, typically my suggestion is stay away from them. Okay? You're giving your employees a lot more rights than you really need to give them. But again, if you're looking for high-end talent and that's what they need, nothing wrong with an employment contract, but I wouldn't do it unless I had to. So let's get back to this cause and no cause. If you terminate somebody for no cause, it's as simple as, thank you very much, today's your last day, we don't need your services anymore. Done. That's it, no reason. You don't have to keep them employed. Off they go. If you're gonna do it for cause, and there's pros and cons to each of these, that means, hey, you were late for the 74th day in a row. You didn't even call me 3 of those days. This isn't working. I'm terminating you for violation of company policy. The tardiness section 17.2/4 says you can't be late. You're late. So off you go. So why does it even matter? If you terminate somebody for no cause and they meet the other requirements, they're gonna be entitled to unemployment compensation, because in essence, that's a layoff. If you do that once in a while, no big deal. If you do that too much, then your unemployment compensation, your unemployment insurance that you pay for starts to go, and it can become very expensive. So if you do too many no causes, that's what happens. Now let's go back to for cause. If you do for cause, typically it makes somebody angry. I don't care how bad they are, how awful they were, it's your fault they got fired. Almost every time. So that invites litigation at times. Oh, that's wrongful termination. I wasn't late 74 times, I was only late 60 times. So we get all these kind of problems here. I'm not kidding when I tell you this. I saw in Annapolis in a hearing for unemployment where somebody was claiming that their termination was wrongful and they were therefore due unemployment. The employer said, look, they were late all these times. And the administrative law judge down there said, well, show me in your handbook where it says they can't be late. Handbook, not handbook. How does he know he's not supposed to be late? Unemployment compensation granted.
Wow.
So I'm telling you now, the cards are stacked against you in that regard. So a good employee handbook is critical. So let me review quickly the pros and cons of these. If you terminate for cause, you're protecting yourself against unemployment claims. Unwarranted unemployment claims, you're keeping what you pay into that fund down. So there's a good reason to do that. But you better have your ducks in a row. If you do it for no cause, they have very little way to come back at you for wrongful termination. You just don't need them anymore. At will state, at will employment. But if you do that too much, it's going to cost you money in the long run. Okay, so I asked about employment contract. They are express or implied. So any written policies you put out, please have them reviewed by somebody, an attorney, because the courts are also holding, well, this doesn't say employment contract on it, but what it says is that if you do this, I'll do that. I've seen documents prepared that in essence were supposed to be the rights and duties, or the duties and responsibilities of the employee, but it becomes an employment contract. So be very, very careful of that, because now if they got an employment contract, termination becomes much more complicated. You don't even have to raise your hand on this one, but if you don't want to. But how many of you have in writing somewhere that your employees are on probation when they're first hired, or an evaluation period, or probation period? Okay, don't do that. The courts have also held that, gee, if the first 90 days they were on probation, or the first 60 days is an evaluation period, then it must be something different after that. And if it's at will for the first 90 days because it's probation, then it can't be at will after those 90 days. So what we have is an implied employment contract. So if anybody in any of your writings, and again, I can help you with this if you want, but get some advice on it. If you have that in there, like, oh, we can let you go at any time for no reason at all in the first 60 days, what you're telling the world is, well, after that, that must be different. So there's no longer employment at will. Don't mention probation, don't mention evaluation period, nowhere. They're on probation the entire time they work for you. Every day till they no longer work, they're always on probation. You can fire them at any time. That's where you want to keep it. All right, document. Hopefully you have written policies, hopefully you have employee handbooks. But I know it's really easy. Again, I come from the business world, I know how busy you are. But when that person is late, when that person gets a customer complaint, when that person violates some policy, write it down, document it. Even better, they don't have to agree to it, but have them initial, have them sign, yeah, you told me I was late. You told me 3 times I was late. Document, because you're gonna need it. they bring up a wrongful termination claim against you, what you wanna be able to do is say, here's the employee handbook, here's my written policy, here's where they sign that they've received the handbook, here's where it says, if you're late more than 3 times, you can be terminated, here's the date where I warned them once, here's the date where I warned them twice, here's where they were late the 3rd time. That's what it's gonna take for you to win. It's gonna take that for you to win. So no matter how busy you are, document it. Doesn't need to be a book, a couple of sentences. Here's what we talked about, here's our policy, sign that you received this piece of paper. Okay. Always follow your own written policies. The other way you can get in trouble on this is, well, my policy says this, but I did that. You're dead in the water once it happens. Always follow your policy. If it's a policy you don't feel like following, change the policy. Get it out of the handbook. You can do a short addendum saying section 2.4.3, now read this. If the policy's not working to the point you're not enforcing it, change it. Because again, you're gonna get slaughtered in any kind of a hearing if that's what you're doing. And enforce those policies uniformly, okay? Sometimes I get the, oh, I got this guy who's not really working out, I wanna get rid of him, so I'm gonna enforce this. I'm like, well, are you enforcing it on everybody else? No, but I don't like this guy. Don't do that. You can't do that. Because again, if they're able to prove that in court, you're toast, you're done, you're gonna lose. So you have to enforce these policies uniformly. If you're telling this person they can't be late, you can't let your favorite person be late. It's just that simple. You can do it. Okay? And you've probably already gotten this from what I've been saying, but the burden of proof is gonna lie squarely on you. This is absolutely a case where you're basically gonna have to prove your own innocence. And the only way to do that, written policies, employees have signed that they've received them, you've enforced them uniformly, you've documented their mistakes, you've documented their transgressions, you've documented their violations, you've followed your policy from start to finish, you'll be fine. So I don't wanna make it so scary to think that you can't ever prevail and how unfair this is, but you've got to do it the right way. And if you hire somebody, eventually you're gonna fire somebody. That's just the way that it works.
John, I think we have about maybe a couple questions.
Yep, I think that's it, because I am otherwise done.
Oh, perfect. I read your mind.
Yeah.
Anybody have any questions for John?
So if you've got a payback period, so you pay for training or you pay for equipment or something for somebody, and you know, if I pay for training and it costs $1,000, and if you leave within that year, you got to pay back a prorated version of that. Is that considered a contract? Or?
It is, but it's not in a contract for employment, it's a separate type of contract. Those are valid. If you are paying out of pocket for training and things, you do have the right to say, hey, if I'm gonna spend all this money on you, you gotta work for me for a certain period of time or else you're gonna owe it back. They have to be drafted the right way, and the payback period has to be reasonable. It can't be like, okay, I paid $1,000 for you, and if you don't work for me for the next 20 years, you're gonna owe that $1,000 back. So it has to be reasonable in terms and scope. What else?
Will you handle unemployment hearings?
I have, I can.
I've done one, it was the worst thing ever.
They're fine on it.
It was the ex-employee, the attorney, and myself.
Yeah.
It was like,
Yeah. It's about as close as you'll get to people's court.
yeah, it was. It feels like
It does. All right, what else? Back there?
Give you a little bit of a story. Client of mine does the probationary period, 60 days, for executive assistant. You have 6 days as a contractor, day 61, full-time. That employee got fired after like 30 days, wanted to go for unemployment. The whole contractor status came in. He complained disgruntled, filed a complaint to the IRS for contractor. IRS came in for an audit for contractor's employee with all that fun stuff. Turned into a full-blown audit on 5 tax years, a couple $1 million later. All the over $400 unemployment. So, yeah.
Careful, pick your battles.
Yeah.
One of the hardest things I have to do, but it's one of the best and most right things I have to do, is I have to look a client in the eye sometimes and say, you're absolutely right. Facts are in your favor, you're absolutely right.
Yeah.
Well, we're not gonna do this. Because it isn't worth it. The risk just outweighs, consider it a business expense, pay the $400, move on. I mean, part of me, I hate giving that sort of advice, but like, what price justice? Apparently $2 million.
$2 million.
Yeah.
I have a question about that too, like, cause I do some handbooks in the HR consulting side, and I've been asked the question, like, well, how much could my unemployment insurance actually go up? And I don't know the answer to that. I don't know if you have any insight to that in Maryland specifically, like, how many people do they have to fire before it doubles?
Yeah, I don't have an exact answer, and I've tried to find an exact answer,
can't
because
find it.
as far as I know, there's no published formula. But I'm gonna tell you, it's somewhere between 5 and 50, and that's an awful answer. If you're laying off, firing for no cause, separating for no cause, a couple people a year, I don't think there's much difference.
But is it like a percentage of your workforce, or like the number of?
I believe it's an absolute number.
Oh, okay,
Yeah.
okay, yeah.
But again, I can't find a formula for
Because
it.
also sitting in those meetings with, saying this is a termination for cause is very uncomfortable for the employer, for HR, for the employee. So, and that's kind of weighing, like you're weighing into that too.
Yeah, and some of the factors are, I mean, particularly the larger your workforce, if you've got somebody that was stealing, and they're on camera, they were stealing, okay? You know, you may want to terminate that person for cause, if for no other else, to keep your company culture straight. You steal, you get fired, okay? I get that. So sometimes there are other considerations that you have too, like, you know, if you can steal here, and I don't wanna face the battle, and you stole a couple $1,000s and I just let you go, well, what are you telling your other employees? So that could be a factor too.
Thanks, John.
Sure, you're welcome. My
Everybody,
pleasure.
John Wheatman. So, thank those great questions. We're gonna cut it off here. John can probably, follow up with anybody. He has cards going out now. That's
I'm gonna
good.
ask you
So
to
please give
pass
him
them
a call.
down.
Thank you.
And I believe he also has a retainer. He can also be on retainer for your company, right, John? So, just to summarize, these happen every quarter. Input by our membership would be great for subject matter for the future. We will put that in place. One thing I kind of want to talk about is the kind of the two things going on with the chamber at the board level, and what we're trying to do is develop a really great product. Greater Mount Airy Chamber of Commerce. That's what we're trying to do. But you know, the byproduct of the chamber is available to everybody in Mount Airy, right? Whether they're members or not, because the things we're doing are promoting business in Mount Airy. Greater Mount Airy, thank you. But people don't have to be members. They can be business people, and they're enjoying all the byproducts of all the great work we're doing. So why join? Because of the exclusive nature of events like this. We're trying to do things for our members. All the networking events. It's sort of like, you know, joining any club. You know, you want to have the activities for the members that are, that you think that are most important. And professional development is probably one of the really big things we're trying to work on right now. So we would enjoy your feedback, and Helen is open to hear back from you about that for the future. So again, thank you. I think there's food.
There's food.
If you want to have
Make sure you
seconds
take
over
some.
there.
I wanna,
and-
Yeah, before you all disperse, we're batting around some other ideas for topics. One of the ideas is cybersecurity, how to protect your business, and trying to gauge if there's interest in that, and raise your hand if you say, oh, I would definitely attend that.
Spend a lot of money on there.
Okay, okay. So, I can't remember what else we were, that's the next one I thought of.
Mhm.
Was that it? Okay. And I actually have this amazing cybersecurity expert lined up, so at least I'm trying to schedule, so.
Let us know if you think of anything afterwards, yeah.
Yes, I know I've been planning to send out a survey, but have not. But, yes, just come up to me if you say, hey, I would love to see, something on this, or, you know, most of you know me and have my email, so you can contact me. Just feel free to send me ideas anytime. So, definitely take food. We can't hang on to it, so please fill up before you leave.
Thanks again, John, one of the smartest guys I know. Thanks, John. See you guys next quarter, if not before that. Thank you for coming.
Awesome.
And I'll be here too if anybody needs to talk about.
Did you videotape this?
We do videotape that.
Where